What's up, people? How we doing? What is up? Happy Maniac Monday, and we certainly have maniacs on deck. Who watched that DeSanto video I just dropped? She did what? What's up, people? How we doing? It's your boy Phil. We're gonna have some fun today. And let's start with my boy Judge Stevens from Texas. He was on a roll today. Nobody in timeout, but can you figure out what he says here? Could you help me out? I don't know. Help me out, guys.
Okay. Mr. Kimber.
Ready.
Okay.
Okay.
Mr. Kimber.
Ready.
Okay.
Mr. Okay.
Y'all working on trying to dispose of this?
Well, I think he's.
Are y'all working on
Okay.
disposing of
I
it
don't think he's gonna.
generally?
We're here.
No, because I don't think he's going to show up.
But wouldn't that dispose of the case? This is what I'm saying.
What-
It's a global statement.
Yeah.
What will get it?
He's
if
been
that's the
served
way
as
it's
far
gonna
as I know, Your Honor, and he will be here. I've talked to him in
Charles,
person here,
I am.
so he understands that he would have to be here, and he's been subpoenaed, so he'll have to be here.
They are married.
Also
That's
has to
sort of spousal privilege.
Okay. Okay, but I'm not going to put them in, and everybody get ready for a trial if it's ridiculously not going to be set. If it's ridiculous, not going to be occurring. But if we can dispose of it with this in this way, let's dispose of it. Putting aside what some of the editorial comments I'd make about someone who decides they have to pursue a case and then later change their mind. And I'd like to send a bill for the cost of everybody relying on those representations if they're going to change their mind. That's what I would like to see, as a bill sent to somebody to pay for the costs for this, since we relied on somebody's sworn document. That's my editorial comment, because I find it preposterous, and the people who I hear from also find it preposterous. Tax money being misused this way.
Not happy.
I'm not blaming you. I'm not blaming you. But let's not waste any more money. And I'd like the person to come up here and tell me. I'll certainly grant it. I want to look them in the eye and quiz them on how they swear one way and then now are swearing another way, and ask them how that works under the rules. Don't interrupt the court, under the rules of.
So he's not yelling at defendants. He is giving it to the prosecutor, the public defender, the cops. He's giving it to his colleagues.
Reliance on oaths. I presume there was a sworn document filed.
Yes, sir.
I don't think he's saying it didn't happen.
Okay. Well, then
What's up, Steve?
if y'all can.
Yes, Charles. I do agree with you at Fresh Hour, but DeSanto has my heart. I love raspy. I'm sorry. I'm a raspy guy. Correct, Charles. Correct.
Resolve it without getting here, but here's the deal. Parties are not going to dictate the direction of justice. Once it's filed, it's in somebody else's hands.
Mhm.
And then I expect people to be subpoenaed and under oath and tell the truth. And it shakes out the way it shakes out, unless
Welcome from Biggin.
everybody can agree so that the circus does not come to town. No, I just don't like that.
Yes, sir.
The old saying, tail is wagging the dog, is what happens in these kinds of things. And parties will not be manipulating their personal whim and will and cost all
Thank you, Matt.
time, energy, and money, and then begin with their will and then end on their will, and then they are in control of something that law is supposed to control.
Do you want to just reset her for trial, or?
And we're ready, Your Honor, on it, and
Okay, but I'm
That I
saying,
wasn't ready.
at the end of the day, it's best if people who have a relationship work things out, fine, but it should cost for the effort, time, and energy that somebody causes the system to rely on. But you know, there's always ways of fixing an error, but sometimes you got to sometimes financially it costs. Otherwise, this is a charade, what we do, and it's just a tool used by people to manipulate, which is forbidden.
And there were some severe injuries in this one, Your Honor, and we believe we've made more than a fair offer to try and resolve it based on all the factors, the victim's wishes as well. So.
The domestic dispute.
Once again, the court stands by its saying. All of that being said, you know, let's see if it can be disposed of without the need of a trial under these circumstances that are being inferring to the court. I know what it is. I mean, I'm not foolish. I'm not naive. But what aggravates this court is we are overwhelmed with criminal cases. We don't need people to manipulate.
Hello, Priscilla.
And
Welcome.
We all learned crying wolf was a first grade fable. We all learned that's not right.
Well, I think he did get stabbed.
And notwithstanding,
Thanks for the
once
dono.
somebody decides to swear a document, it's
Agreed. Everyone has a hard time in front of Judge Stevens. If you're not following his way of thinking, you're either scourge or in timeout, or you're both. Because of scourge, you're in timeout.
in the system, and
Thanks
we
for the
rely
donut.
on that. And for them to unilaterally attempt to withdraw it, then parties control the situation that they are no longer in control of when they ask for the system to come in.
You don't bother the system to begin with if you're not going
Yes.
to follow through.
Yes. Yes.
Sure.
It's because that's the way, otherwise laws are meaningless. And when you ask for the legal system to help, then your whim and will is second to the process that's set under written law. And that's not supposed to be changed and manipulated like some cases occur. But once again, those are things that can be fixed. But at the end of the day, it's with the parties. You know, I just know what the people say, and they don't like it. They don't want time wasted and money wasted for people who can't get their romantic interests straight. That's person to them, and if they want to make errors, let them pay for those errors, not distribute the cost to the taxpayers. Then your private matters are no longer private, and strangers get involved, and I prefer not to do that. But when people say, I need help and I'm in the system.
Okay, so Judge Stevens, man, he's not going to have your back if you're not doing the people right. I love it. Absolutely love it. He's not feeling it. So he went after the lawyers. Now he's going to go after the inmates. Let's roll. Thank you for the dono, Mr. Blake. Okay, here we go.
Mr. Kimball.
Oh, sorry, guys. Here we go.
It'd be the last.
Okay,
That's the one
Oh.
for the 33.
oh, see, here's the problem. Is the labels of the name
Yes,
aren't
we know.
sticking out. All
We
right.
know, we've discussed it with the district clerk. They're changing how they're doing it.
Color me amazed once again. 23. I guess that's District Court, DC CR 1. First case of the year here under this new system. You are Faisal Atari, and you were charged here with the third-degree felony of assault. Well, that's not the way it is. It's assault, fam/house member, IMP. So it's family violence.
Right.
Okay. And if convicted, you face no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000. And be assessed. Do you understand? You understand? And
Thank you for the matching dono. Daylight.
announcement.
Your Honor, we'd like to place on the trial docket. I have spoken with the victim in this case. She has indicated to me that she does not want to pursue this. I think Mr. Laird has had similar conversations, so we just need to get this thing set for trial and see if we can get it resolved.
What's up, Cha?
She didn't say she wouldn't cooperate. She said she did not want to press charges anymore, but
Okay.
I told her that looking at the severity of the case that we were going to proceed with it.
Wait, are you contacting this lady?
My wife?
Yeah.
Yeah. I contact with her after the finish the protection.
Don't. I find you contacting her again, I'll hold you in contempt of court, whether you get convicted or not, and I'll add 6 months to your time confinement.
You know, I am father. Of course, I have kids.
Do not
My
contact.
wife. Sorry.
I don't care who she is. You are a defendant and she is the victim. And it's out of your hands. If you can't take care of your responsibilities in a relationship, then outsiders get involved, like me. But on my watch, the order is do not have any contact with the victim. And if I find out you contact the victim, you will be held in contempt of court. Each time I find out, I will add 6 months until it's 600 years. Can you follow the order?
I thought when I first listened, he said, "Did you fart?" I thought he was saying, "Did you fart?" I'm so childish.
Orders of the court? That's the rule of law here. I don't know where you're from. Were you born in America,
Sorry, sir, about that. But
sir?
Sorry about that, but what I read,
Were you born in the United States of America? Where?
I'm born in Dubai.
What do you say?
Dubai.
Dubai. Okay. The rules of America are different from some of the rules in
I
Dubai.
respect the
And
rules.
sir,
They are writing in
sir,
April 8th. This is the last day with the protection.
Sir,
After that,
you have interrupt me one more time and I will add 6 months to your confinement. You can't follow any rules of decorum. It's rude. Plus, it's against the rules to interrupt me. Do not. It sounds like you're the kind of person that wants it on that you dominate the control of the issue, that you are in control. Not right now. You will follow the rules like I have to follow the rules. Which means, number one, don't interrupt. And number two, do not contact your wife. Those are rules. Every time an indictment like yours is handed up, everybody has the same rules they have to follow. And if you violate them, you will be punished. I want to know the moment.
sir.
Set for trial, Your Honor.
Set for trial. That's all. Thank you. Next, John Christian Massey.
Wow. Stevens gets this look. If he's not Judge Angry Grandpa, I don't know who is. Thank you, Rick Russell, for the dono. Thank you, Daylight, for the dono. Thank you, Grim, for the dono. Grim's dono message was great. Judge Dad went out for milk and never came back. Great one, buddy. It has to be a perfect match or it will drive me crazy, Mr. Russell. You are the man. Let's rock and roll. There was more Stevens, but I'm on a jump. Guess who we have back again? Chester Bell is back, and he makes Washington blush. He's hitting on Judge Washington. Yes. I really think I have to do a three-parter on Chester Bell. I just have to find and put it together. Chester Bell is fantastic.
Needs requires they come to court. You have the right to see, hear, and question any and all witnesses that are called, and to be a witness for yourself. You could choose to remain silent. If you chose to remain silent, the prosecutor couldn't comment on that. And in addition to that, you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand those rights, sir?
Yes, ma'am.
You understand you're going to be giving up each and every one of those rights? And
Yeah.
you're not on trial of any sort?
Can you repeat that?
And you're not going to have a
So, if you guys are new to the show or you haven't been following, this is Chester Bell. He has an ongoing hearings and plea deals, and he was sick in the hospital. The first appearance he had on the show, he was sick, and he wasn't missing. He was missing court dates. Washington had it. She tethered him. He was complaining about the price. She didn't care. She tethered him. Second appearance, he was doing very well. He was still a little sick, still a little whiny, still a little complaining. Washington put up with him. Third appearance today, he's hitting on her.
trial of any sort.
No trial?
Right.
No, because I'm just accepting the plea.
Okay, so, all right. And do you also understand, sir, that there's no automatic right to appeal this decision? So the decision you're making today is likely to stick with you. You understand that?
I did it.
Okay. Do you also understand, sir, that if you're on probation,
I did it.
parole, or bond at the time you did it, that you could be in violation of that probation, parole, or bond?
Yes, Your Honor. I should be fine.
All right. And you aren't in any of those?
Not to my knowledge.
Okay. And do you also understand if you're not a U.S. citizen, you could have immigration consequences?
Yeah.
Are you a U.S. citizen?
Yes, but noted.
Okay, thank you. Do you also, okay, so to the charge of operating with a high BAC, second offense notice, how do you plead, sir?
Guilty, Your Honor.
All right. Has anyone threatened you in any way to get to the plea guilty?
No.
Anyone promise you anything other than what we placed on the record?
A Sprite? Just kidding. No, they didn't.
Ooh!
I'm like, you're an easy vibe. This Sprite is having said all that, sir.
Chester,
on
you
November the 8th of
dog!
2022, were you operating a motor vehicle in the area of Bay Tree Drive and Dorrell Drive here in Ypsilanti Township?
That sounds right. I imagine, yes. I don't know exactly the crossroads around, but I imagine.
But you were in Ypsilanti Township and you got pulled over by the police on that day?
Yeah, I was just down from my house.
Okay. And
I was just parked.
But you were operating a motor vehicle?
Yeah, I mean, the keys were in it, and
It was
so,
running?
Yeah.
All right.
I already pled guilty, Your Honor.
Not yet. That's what we're doing right now.
Oh,
We have to make out the factual basis for it to be an accurate plea, Mr. Bell, okay?
Sorry, Your Honor.
That's okay. And so, at the time that you had the keys in the vehicle and it was running, did you, were you under the influence of alcohol at that time?
Yes, Your Honor.
Do you remember what, was there a blood alcohol content test done?
Yeah, like, both, I believe.
Okay. Do you, counsel, what were the results, please?
0.246 there.
Okay, thank you.
3 times?
You
Yeah.
still to that?
I wasn't going anywhere, but
Oh,
it's,
you did. Sorry.
yeah.
I'm sorry, Okay, curiosity, really, did you say you stipulated to those?
Yes, I was muted. We do stipulate to that, Your Honor.
All right, thank you. I find that there's a factual basis for the plea. It has been willingly and knowingly made. Are you satisfied, Ms. McDuffie?
Yes, Your Honor.
Ms. Curiosity.
Satisfied as well, Judge.
Sentencing in this case will be on June 5th, 2023 at
Part
10 a.m.
4.
Mr. Bell, did you write down the phone number when I gave it out earlier? Did you need to call the probation department?
I think so, but I wanted to double check. I got 483-7336.
That is correct.
Oh, okay. All right, cool.
Please call them after 1 o'clock today and schedule a time that be able to have your alcohol assessment done. We need to find out if you need to have any type of treatment, okay?
Oh, is that the online thing? Because I'm on the tether, so they know.
No, sir, that's something different.
Okay, because I spoke with Willie about it.
Okay.
Just trying to make sure.
All right. Case number 22 S00.
June 4th, mark your calendar. June 4th, part 4. I will drop a 4-parter on Chester Bell. He is a character. He is Eeyore Bell. He is Eeyore. Mr. Ho-Hum himself. Judge Washington's fantastic, isn't she? Oh, God. All right, so we are going to roll from Judge Washington and roll right into my boy, Judge Braunlick, and he has a deadbeat dad to the fullest. And just wait till you hear it.
Mr. Wilkerson, the court file reflects an address of 406 Harrison Street. You have a continuing obligation to keep in front of the court informed of any change of address. If you're mailed a notice at 406 and you move to 411, you're not going to get the notice. Go ahead, Mr. Wilkerson.
Yes, sir. I lived at 406. That was a while ago, but I have changed my address, and I got one letter from the friend of the court, and that's when I stayed at 411 Harrison Street, but I stayed at the very bottom apartment 2. I got the first letter stating that y'all might have was going to give me a court date, but that was the only letter I have gotten. But other than that, I haven't received nothing else because our mail, like I was just telling the deputy here, the mail people, they put different people's mail in our mailboxes, and so we hardly get any of our mail. But I've received one letter from them though, and that was it, and that was at a 411 apartment 2. I live in apartment 1 now. I just stay in the front of the house.
Well, isn't 406 and 411 two different households?
It's right at 406 is right across the street from me, and that's
Okay.
my fiance's aunt's house.
Well, you need to be checking your fiance's mail, Mr. Wilkerson. When you get released from jail, you need to go to the front of the court and fill out a form with your change of address. You were mailed notices, not letters, but notices to appear, and you ignored those letters. One was mailed in January 26th. You mailed an order. And also,
my fiance's aunt, she pretty much gives us all our mail, but she haven't gave me nothing like that. And like I said, I received the house that I'm living at now. I've only gotten one statement because I would have never missed court. I would have been here because my fiance's going through it. She can't work. I'm the only one that can work. So, and they have been taking out child support when I was working through Express Temp Service.
Okay, hold on, Mr. Wilkerson, hold on. You're aware that you have an obligation to pay child support, correct?
Yes, sir. They was taking out child support out of my check when I was going through Express.
Mr. Wilkerson, hold on. If you knew you had an obligation to pay child support and you were not paying it, there's a really, really good chance there's a bench went out for your arrest. If you're not paying child support, you're not maintaining contact with the front of the court. That's the bottom line.
Yes, sir.
Mr. Hicks, what's the situation on Mr. Wilkerson?
Your Honor, this case has a current monthly support obligation of $267 per month. The current arrears balance is $17,196.43. The last payment we received was December 23rd of 2022 in the amount of $50.54, and that was from a temporary service.
How much was that in December? $50?
$50.54.
Were there any payments before December of 2022?
Yes, Your Honor, we did receive payments. In total, in December of 2022, we received $209.81. In November, we received $45.18. And in October, we received $63.41. That's the sum total of payments we've received since this case was registered in the state of Michigan.
All right,
Hey, can I
thank
say
you.
something?
Go ahead,
And with
Mr.
those
Wilkerson.
jobs, with those jobs that was taken out that she just said, those came from the temp service express. And that's the places I was, when I was working. And with my fiance sciatic nerve problem, and she was the only one at the house with our 7-month-old, I had to leave work, but I had doctor's notes, and they did not accept my doctor's notes because of, because
Can someone tell me what a 7-month-old is?
they didn't care. But that's the reason why they was getting payments out. That's why I had that job, because I even called the child support, and I forgot who I talked to, stating that I was working, and gave them the express information, and then that's how they was able to get my information from Express. Because I do not dodge. I mean, I did turn it in, and I'm
Mr.
working now.
Wilkerson, Mr. Wilkerson,
sir.
hold on here. You're
Yes,
giving
sir.
that information that's really not relevant. And you have an
Yes,
obligation to
sir.
pay child support that was initiated in the state of Tennessee. And that order was
Yes,
sent
sir.
to Michigan to be enforced. So you
Yes,
are
sir.
sitting on your hands. You have $17,000 in outstanding arrearages. You're delinquent $17,000, not a couple $1,000, but $17,000. You need to
Yes, sir.
go down to Tennessee. You need to file a petition down there to reduce your support. You can't afford the $267 a month. The Michigan court cannot reduce that. You need to go to Tennessee to do that. This court,
sir.
the state of
That's what
Michigan, is
I'm
simply
working-
enforcing the Tennessee order. And you've been
Yes,
ignoring
sir.
it, Mr. Wilkerson. Ms.
That's
Six,
what
what's
I'm
your
trying to
recommendation
work on.
this morning?
Your Honor, the recommendation of the friend of the court is that we proceed with contempt against Mr. Wilkerson.
Well, I have
All right,
a
Mr.
job.
Wilkerson, hold on, Mr. Wilkerson. I'll give you a chance to ask questions. You understand you're being charged this morning with civil contempt of court for failure to pay child support. Upon conviction, you could be ordered to serve up to 45 days in jail. Because of the possibility of jail, you have the right to an attorney. If you're unable to afford an attorney, the court will appoint an attorney to represent you at public expense. Do you understand all of that?
Yes, sir.
Are you requesting a court for an
Crying?
attorney?
Yes, because I
Okay.
need to get.
All right, I'm
I
gonna
need
ask
to
you a few
make bonds.
questions. The court's gonna
There's no crying in child support.
adjourn this matter to Wednesday because we can't get an attorney right on the spot, so the courts will adjourn this matter to Wednesday, May 3rd, 11:15 a.m.
Put your hand down, man.
So,
Are you currently employed, Mr. Wilkerson?
Yes, yes, sir. I work for
With
Oaks
who?
Lawn Care. Oaks Lawn Care.
Oaks, O-A-K-S. Where's Oaks Lawn Care located?
Monroe, Michigan.
You work 40 hours a week?
Yes, sir. We just started picking up. He was supposed to be coming to court, bringing a letter for me. And I even had an
Okay.
interview. There you go. That's Mr. Darius. That's my boss.
Yeah. Okay, he's here. Hopefully he can post a bond on your behalf, Mr. Wilkerson, and you can work that off. And do you get paid every week or every 2 weeks?
Every week. 'Cause we was trying to
Approximate
get-
average take home?
We just started picking up. A good week, I bring home between 4 or 5.
Average take home?
Average take home, we just between 6 and 7.
Do you own any property of any value, such as an automobile, bank accounts?
No, sir. I got an express account. That's it, just so I can cash my checks. Because me and him, he got me the bank account to where I could cash my checks. It's just an express account. It's not no actual bank account.
When did you last get paid?
I got paid just the other day, and it was only $74 because of the rain. Because it had been raining all week, and we hadn't really been able to get out and work. But we do have a full week this week and next week, and been picking up more yards.
All right, the court will grant your request for corporate attorney, Mr. Wilkerson. The attorney will meet with you in the morning, and the court will schedule us for contempt hearing again on Wednesday, May 10th, 11:15 a.m. That'll be a Zoom. The attorney will talk to you at that time. Ms. Six, what do you recommend in terms of a bond?
Your Honor, the friend of the court would recommend a $2,000 cash bond based on the testimony of the income that he's currently making.
All right.
Is there any way? Oh, sorry.
Hold on just a minute, sir. Just a minute. Can you state your name for the record?
My name is Darius Hudson.
And Mr. Hudson, you own Oaks Lawn Care, is that correct?
Yes, I do.
Okay, and so you're acquainted with Mr. Wilkerson?
Yes. Yes.
Go ahead, you have a question?
No, not a question. I just wanted to say something on his behalf. He's correct about us just getting started. And this is his second year with me. And we really built a clientele based on him. And he's such a great worker. And we're just getting started. He lives right on Harrison. We cut grass at the Assembly of God right next to the church, to the police station. He's not a flight risk. If you could just let him get 1 week to get some money in here, because oh my God, like, I don't want to be a beggar, but the guy is such a great worker and he's making the change. I've come through your system. I've paid $70,000 in child support. I owe zero. I have 7 felonies and I'm able to hire several people in Monroe County. And I really want to work with this guy. He just needs a chance because he is really doing well, so that's it. If he can get to work, he'll be back at work tomorrow laying mulch right here in this very community. He is not a flight risk. He can come back next week to your office and come in there I'll bring him to you with the payment, when he get his check. But if he stays in there, it's going to hurt him, me, and you need money. So he needs to work. Wait a minute, man. Wait, stop. Let me talk for you this time. Yeah, he needs to work. I need him in my company. We are really in a position to go somewhere. But I even work a second job, as you can see, 1 day a week, and I took that day off so I can be here to let you guys know that he has support. And my wife runs this store in the community. We are not leaving. So if it's possible, he can get a PR for 7 days. This can be your success story. He doesn't do drugs. It's not that type of situation. So that's what I want.
Thank you, Mr. Hudson. Thank you for appearing in the court. Has no doubt that Mr. Wilkerson is a good, dependable employee. But the fact is, he's ignored his child support obligation. This court has an obligation to make sure that child's provided for. He has $17,000 of arrears. I don't know if you heard that, Mr. Hudson. $17,000. This is not a criminal case where the court's not sure about his appearing. This is a court where we need to collect that child support. So at this time, the courts will require that a cash bond be posted of $2,000. If you want to post that, he can be released home for dinner tonight, back to work. You can then collect that from his future earnings. If you know he's a good employee, he's dependable, he can work it off through you. But that's what the courts requires, a $2,000 cash bond at this point in time. We could reevaluate things on Wednesday, but you can appear once again via Zoom on Wednesday, 11:15 for the contempt proceedings.
Okay, that's what we'll have to do, because after this week, I can bring it in, but I've put so much into getting us started this year that I won't have money to bring. But I'm willing to for him because he's worth it, but I don't have it myself at this time. I appreciate you hearing me, and I'll be there Wednesday.
Okay, so 11:15 on Wednesday, Zoom hearing. Mr. Wilkerson, do you have any questions for the court? Maybe you can reach out to other family and friends, but you need to be proactive on this obligation. You need to file a motion with Tennessee to reduce your support. You can't afford the $267 a month, and you need to have a full-time job. You can't be just seasonal, Mr. Wilkerson. There's a couple of suggestions for the court, but this matter is continued to May 10th again, Wednesday, 11:15 a.m. Court will grant your request for corporate attorney. And if you want to be released, you must post a $2,000 cash-only bond. Any questions, Mr. Wilkerson?
So, sir, so this $2,000.
Correct. Enough to lie toward your arrears. Not going to court costs or fines. It's going toward your arrears. It's going to go to your child.
I understand that, and I would love for that to happen. That's why I've been working on trying to get the tax doctor because I'm in the process of going through the tax doctor, getting my taxes done, because that's a lot of reason why child support has me, because I haven't done my taxes. And my W-2s is just all over the place from where I was traveling, being an iron worker, and then I resigned here, and I'm still trying to get all my mail and information so I can do my taxes.
Okay. All right,
Because I'm
Mr.
trying
Wilson,
to
do
get
you
my
have a cell
rent
number?
paid.
That, in case you post bond, I'm gonna give the attorney a cell number. Do you have a cell number you can provide the court?
734-577-7763.
All right, well, in the event you post bond, you need to appear then on that May 10th at 11:15 a.m. And we'll give the attorney your cell number.
I'm gonna try. I'm gonna try to
I'm
get
May
all the-
3rd. I say May 10th, I meant to say May 3rd, Wednesday of this week. The hearing
Well,
is
I'm gonna try to
Wednesday
get
of this
all
week
this
in
up
2
on
days, Ms. Wilson, May 3rd. I apologize for stating May 10th. Were you able to catch
Well,
that, Mr. Hudson? It's May 3rd, not May 10th. Okay, looks like Mr. Hudson left. Okay, so anything further, Ms. Hicks?
Nothing further, Your Honor. I'll prepare that order and upload it shortly.
All right, Mr. Wilson, you can step out. If you post a bond, you must appear Wednesday of this week, 11:15. If not, then we'll just do them for the county jail on Wednesday for further proceedings.
Pay
All
your
right, sir,
bills,
you
bro.
can step out.
And he's lucky he's got that guy helping him out too, man. He's lucky he's got that guy helping him out. That guy's a saint. All right, here we go. Let's do it. So, crying is the theme here. I found another crier. We haven't seen him in a while. Let's see if you guys know who this is. I'm not going to say his name. Let's see if you guys know what judge this is. My court nerds.
Significant concerns about this case. That is the correct address that the court has, and therefore that's how you got your notice today to appear. I assume you've also got a notice for the fact that you have a jury trial set on May 22nd, which is only 21 days from today. You have that notice, correct?
I got the notice from the court, yes, but nothing from my attorney. Like I said, I've had no contact with him.
Did you get notice, Ms. Bonifant, from the court?
I did get the notice from the court, yes.
When did you get it?
About a week ago, actually. I've been in and out. My son passed away in December, so I've been in and out of.
What I'm trying to understand, Ms. Bonifant, is I'm trying to put myself in your position and understand why a person charged with a felony offense who receives notice for a criminal jury trial where the maximum penalty you're facing is 10 years in the state prison system, why, despite all of those things being clear now on the record that you got the notice, the date's set, that you have not had any contact with your attorney? Can you help me understand that?
I tried to call his office. I called his office several times and left messages for him to return my calls, and nobody ever returned my calls. I've been waiting for something in the mail. I've not received anything in the mail from my attorney.
What
or
office number did you call?
Houghton Lake office number that I have it at home.
Well, Ms. Bonifant, you leave me with a very difficult decision because your attorney, who's a sworn attorney, meaning he has a duty under the court rules to tell me the truth in the court all the time. Your attorney stated on the open court record as an officer of the court that he's received no calls from you. He can't reach you, and he sent letters to you. You're saying the exact opposite. What should I do in your mind?
I'm sorry, Your Honor, but I'm telling the truth. I've not received any correspondence whatsoever from him, and I have tried to make contact. I have zero emails. I have nothing. And I have a UPS app that shows every piece of mail that's been delivered to my mailbox, and that's not in there.
Do you think I should keep your jury trial on, or what do you think I should do, ma'am?
I don't even know what the plea offer is. There's a lot to the case. My son was the passenger in the vehicle. He pled guilty to it.
Ms. Bonifant, you need to understand that anything that you say on the open court record could be used against you. I say that for your benefit and protection. If you say things about your potential defense, the prosecutor will be aware of it. She could use that in a way that harms you. And so if it relates to anything about the underlying case, you probably should not speak right now. Do you understand?
Okay.
This case started with a date of October 23rd of 2021. We're quickly approaching 2 years old, Ms. Bonifant. So the fact that you have not had the communication, whether it's your fault or your attorney's, about the case and what the plea offer is, gives me significant anxiety. Mr. Gurmurthy and Ms. Koch, what I intend to do at this point is to have the attorney state for the record whatever plea agreement is in place. Hear the attorney's suggestions on how we ought to proceed and then decide. Ms. Koch, any objection to that process?
No, Your Honor.
Mr. Gurmurthy?
No, Judge, and I'd like to also clarify for the record when the court gives me that opportunity.
Go ahead.
Just the last in-person contact I had with Ms. Bonifant was on 2/22/2022. The last phone conversation she has called my office that I have record of is October 29, 2021 at 2:58 p.m. And the number she called from was 989-335-3135. I spoke with her on that day, and we discussed regarding her matter and her plea. Since then, she has not called my office. I have no record of her calling my office, and I have no record of her calling my office with that phone number I stated on the record.
Lying.
All right, so Ms. Koch, what is the proposed, or is there a plea offer that's been offered?
There is, Your Honor. The plea offer was plea to a lesser charge of possession, less than 25 grams. That's the 4-year, dismiss the count 1 possession of methamphetamine. It looked like she tried to enter a plea on 1/3/22, but was unable to do so.
Mr. Gurmurthy, is that the plea offer that you understood?
That is the plea offer that I understood, and that is correct, that she tried to enter a plea on 1/3/2022. At that point, the court reset it out for 30 days, and that's when I met with Ms. Bonifant again on 2/22/2022.
And then is it your impression or is it your recollection that you've had time to talk with Ms. Bonifant about that plea agreement?
At that time, I did, yes, Judge.
Ms. Bonifant, did you hear the terms of the proposed plea agreement?
I did.
Do you recall trying to enter a plea in January of 2022?
I did, and Your Honor, I cannot tell you that I willingly and knowingly possessed anything, because that was not the case.
Ms. Bonifant, here's what I'm going to do. Well, first, Ms. Koch, you have a suggestion on how the court should proceed?
Your Honor, if the court wants to recall this case, it's stacked with Chris Dussault, who's lodged. So that may actually resolve the issue that we have anyway, because Chris Dussault is likely to go to trial. I think he's next on the docket, and then we'll know which one's going. So that may actually not be an issue if Mr. Dussault's going, and I anticipate he is going to trial.
Mr. Gurmurthy, do you have any suggestion?
I'm fine with that, Judge. And that's still Ms. Bonifant's number. I can call her and talk to her about her plea again, explain to her her maximum penalties, and see if she would want to tender that plea or simply keep it on the trial docket.
The court is going to set a status conference next month. Ms. Bonifant, you're going to get a notice in the mail. It's going to be via Zoom the same way. And when we return, the first question I'm going to ask you is, have you had enough time to speak with Mr. Gurmurthy? If I find that you've had not had enough time to speak with him, I'm going to likely issue a bench warrant, which will put you next door where I know that you can speak with Mr. Gurmurthy. Meaning my order to you and my order to Mr. Gurmurthy is similar. You each have a duty and an obligation now by court order to speak to each other so that this case can move to the next step. If we need a jury trial, I'll set that jury trial at a later date, but I'm not going to have the trial on May 22nd, no matter what else happens. Because Ms. Bonifant, you've not been in contact with your attorney. If you're telling me it's his fault, keep telling me it's your fault. But either way, if there's no contact, now that I'm giving that direct order to you, Ms. Bonifant, and to Mr. Gurmurthy, if I need to next month, I'll make findings. And if I find that it's your fault, you haven't been in contact, Ms. Bonifant, then I'm going to issue a bench warrant. If I find that it's Mr. Gurmurthy's conduct that has created the problems, then I'm going to have my own response for what the attorney will need to do given that. Do you have any questions about what we're going to do at this point, Ms. Bonifant?
No, I understand.
Next month will be a plea cutoff. That does not mean you need to take any plea. You don't. It just means that's the last time. So if you want to take a plea, understand what the terms are, what it will mean for you, and be prepared to do so. If you don't enter a plea, that's fine. But that means I'm just going to set your case on the trial docket, and that's the next way we're going to proceed, as a jury will determine whether or not there's enough or there's not. Do you have any questions now that we've gone over that?
No, I feel like I'm in a no-win situation.
Ms. Bonifant, I'm going to have you provide your telephone number for the record. That way your attorney has it. Go ahead.
989-335-3135.
Is that the number you have, Mr. Gurmurthy?
That is.
Could
I
you,
will respect that.
could you
Two of
ask the attorney what address he has for me again, please? I think when he,
I think I am going to make that phone call, Lisa. I'm going to call. I will be the lamb to call the 33rd District Court and see what's going on. I will call. I promise.
said it the first time, he had 10860.
18060 Hadish Road. Is that right?
That's correct, but I thought that he said when in the beginning that he had 108 because I've received nothing from him.
Mr. Gurmurthy, what address do you have?
18060 Hadish, Hillman, Michigan, 49746.
That's correct.
With that, we are done today, Ms. Bonifante. I hope that you have those communications that I've ordered so I don't have to make a decision that will be probably contrary to your interests. We will see you next month for that final hearing.
Thank you.
Court, you're all set today, Ms. Bonifante.
Thank you. I'm not sure how to get out.
Thank you. So the court has a William Farrar. He looks like at 9:30. I don't see that I have Mr. Trush yet. Oh, I do have Mr. Trush. I don't have Mr. Daughtry, but it looks like that was set via Zoom. Mr. Gurmurthy, have you been able to be in contact with Mr. Daughtry?
Oh, yes, Mr. Daughtry has had very good contact with me. I'm very surprised that he is not on Zoom.
We'll come back to that. I'm going to call Mr. Farrar in. We'll handle the Farrar matter at 9:30, and then we'll call Mr. Daughtry's case one way or the other. So, Mr. Gurmurthy, you can mute yourself and try to reach out to your client.
I will, Judge.
Farrar now. Thank you. The court next calls the matter of People of the State of Michigan versus William David Farrar, file 22.
How good was that one? Here we go, people. All right, next up, I have a two-parter Webster. Okay, I condensed it for us. She sent somebody away, tell him to come back, and he came back during first appearances. So I am going to give you parts 1 and 2 back to back. Welcome everybody coming in. How we doing, people? Let's get it going. Here is part 1.
23 CR 27, 23 CR 40, and 23 CR 164, all captioned State of Kansas versus Raul Gonzalez. Please announce appearances.
On behalf of the state.
Your Honor, Darren Patterson appearing on behalf of Raul Gonzalez. Mr. Gonzalez does appear via Zoom audio visual. Your Honor, I would announce at this time pursuant to plea negotiations, Mr. Gonzalez would enter a plea of no contest in 23 CR 40 to the charges within that case, and also no contest to 22 CR 15. And I'm sorry, that might be 23 CR 15. And he's pleading no contest to the charges therein. The state's agreed to dismiss the other 2 cases.
That's your agreement, Mr. Regier, on behalf of the state?
It is, Your Honor.
Mr. Gonzalez, that's your plea agreement?
Yes.
All right. You have 4 cases in front of me, 2 being dismissed, 2 you're going to plead to. Let's sort through all of that. We'll start with 22 CR 15. In that case, 23 CR, no, got too many of these to keep track of. You have a 23 CR 15. Is that one of them he's pleading to?
It is, Your Honor, 23 CR 15.
All right. So in 23 CR 15, Mr. Gonzalez, you're accused of violating a protection order on March 29th of 2022. And the state's alleging in count 1 that on March 29th of 2022 throughout April 2nd of 2022.
All right, all the people that got hidden accidentally, I unblocked you guys, so you're good to go. Grab your memberships. Thank you, Mark.
You did violate a protection from abuse order issued in Butler County District Court Case 22 DM 103. A Class A person misdemeanor. They're alleging in count 2 that between May 4th of 2022 or thereabout, you again violated a protection order in Butler County District Court Case 22 DM 103. Another Class A misdemeanor. How do you plead to those 2 counts, sir?
No contest.
Okay. Now let's look at 23 CR 40. In that case, it is alleged that you violated a protection order on May 18th of 2022. In violation of that case 22 DM 103, how do you plead to that?
No contest.
It's also alleged in count 2 that you violated a protection from abuse, or a violation of a protective order, I should say, in 22 DM 103. How do you plead to that?
No contest.
Now, is anyone making you enter these pleas today by any kind of threats or promises other than your plea agreement?
No, ma'am.
You understand you're giving up your rights to your trial in
Alvin,
these
you
2
nut.
cases if you proceed with this plea agreement.
Yes.
You won't get your trial back and you won't be able to appeal a conviction. Do you understand that?
Yes.
Now, on the other hand, the state has agreed that they will dismiss 23 CR 27, violation of a protection order on December 30th of 2022. And they're dismissing that, so it can't be refiled. And they're also dismissing 23 CR 164, violation of a protection order from September 13th of 2022. Mr. Regier, is that all correct in keeping with your plea agreement?
It is, Your Honor, and as far as the factual basis goes, the affidavit in the first case does appear to indicate a series of multiple text messages that were sent by the defendant in violation of the protection from abuse order. Similarly, there appear to be 2 affidavits in the second case, also which appear to detail a series of text messages, which appear to have been sent in El Dorado, Butler County, Kansas.
And that's true in both cases?
That
It's
is
based on text messages that he was sending to this person that was the alleged victim in these 2 cases of domestic orders?
That is my understanding, Your Honor.
Okay. All right. I will find the defendant guilty in both cases. Recommendations for sentencing?
Your Honor, pursuant to plea, the state's recommending 12 months for each count in both cases. The counts to run concurrent within, but consecutive between the multiple cases. An underlying sentence, so for a total underlying sentence of 24 months in both cases. 12 months court services probation with all standard conditions, no contact with the victim, all standard costs and fees, which I believe would be $158 for the court costs and $60 for the probation fees. I believe that the state is not seeking restitution or fines, and it looks like this defendant still needs to be booked and processed since he has not done it yet. I believe also there may be some indication about going through a third party regarding certain forms of contact.
Mr. Patterson, why has your client not complied with the order to be booked and processed on each of these 4 cases?
Judge, I only became aware of that last week when I was communicating with Ms. Norris about plea negotiations. So I don't have much of an explanation for that, other than I have discussed that with him. He does know that he needs to get that done very quickly. Judge, on that other issue, they do have a child in common. So Ms. Norris had stated she would agree that they could communicate through a third party for purposes of the child only.
So Mr. Gonzalez's victim is what, his wife or the mother of his child?
Well, at least the mother of the child they have in common, Judge. I don't know about whether they were ever married or not.
Mr. Aguirre, was this woman given notice as a right as a victim in each of these cases to be present today?
Your Honor, I do show notice was sent in 23 CR 15 and it would appear that notice was also sent regarding today's hearing in the 23 CR 40 case.
Okay, thank you, Mr. Aguirre. All right, Mr. Gonzalez?
Yes.
Did I not tell you to go out and get your picture and prints taken?
I really don't remember, ma'am, but I can go over there today. I'm off of work, so I really don't. If you did, I had a lot of stuff on my mind, and you know.
Sir, you have 4 cases in front of me today. And I typically, in every A and B misdemeanor case that comes before me, order that a person goes out and gets their pictures and prints taken. That's Kansas law, and I do my best to comply with the law that I'm entrusted with. Let me check some of these notes, see what I find. Deputy Caulfield, do you have any indication that I ever told him to go out on any of these 4 cases? I mean, I know you wouldn't necessarily have that, but yeah, March 23rd, 2023, and the 23 CR 27, bond was set at OR 2,500. You never went out and signed an OR bond? '23 CR 15. Sir, I'm not hearing your answer.
Oh, no, ma'am.
March 23rd in the 2023 15. Go out and get your picture and prints taken. 20 OR bond. Let's look at 40.
And Your Honor, if it helps, I have notes in both cases which suggest that the defendant was ordered to be booked at the previous March 3rd hearing by today's date, May 1st, 2023.
Frito Bandito.
4 times, Mr. Gonzalez. I didn't ask you, I ordered you to comply with the law that says go out to the county jail and get your picture and prints taken. 4 times you ignored that order. And you say, why did you do that?
I have a lot of stuff in my mind, Judge. I'm living in a rat hole right now, and I work out of town, and I only make $300 a week, and because it's just a lot of chaos is going right now. You know, my house is in shambles.
I have a lot of things on my mind too, if you believe it or not.
I just overlooked it, and I apologize, and I can go take care of that right now. I mean, I'm not a criminal. I'm not.
You're not a criminal? Yes,
I'm not a criminal.
Yes, sir, you are. You've just become a criminal by entering these pleas of guilty to these crimes. Now, let me tell you what, sir. Here's the problem you put me in. By ignoring 4 of my orders, I don't know that I can trust you to comply with any of my orders from this day forward. And in order to put you on probation, I have to trust you to comply with my orders.
I
So,
understand.
what am I supposed to do?
You know,
The only way I can make you comply with my orders is to put you in jail right now and not grant this probation that you've negotiated 2 cases away for.
I really don't want to go to jail. I mean, I want to work. And
Then why
and
don't you comply with my orders?
it wasn't intentionally, ma'am.
Well, it
Like
may
I
not
said,
be intentional that you don't apply with my future orders. How do I know what's intentional and not intentional in your mind?
I just plain forgot. I'm telling you the truth. I forgot.
I have too many people on probation to allow people that just plain forget to be on probation.
May I be heard?
Why not? Go ahead.
Judge, I can tell the court that when I did meet with Mr. Gonzalez, discuss these cases with him, that it did appear to me that he was sincere and that he really did not understand some of the issues that were going on in the PFA violations, that I had to explain very clearly with him what they meant. And I wish I would have been assigned to him back in 2022, maybe when the first one happened. We might not have the others, because after discussing those with him and really making it clear that he could not respond to text messages that were being sent to him or it's a violation, he started getting the idea. So I think it's a matter of setting him aside, really discussing things with him, making sure he understands very clearly what the issues are and how it's to be handled, that he then does comprehend. So I can't tell the court about the first appearance. I think it was a first appearance on all the cases at one time. But I can tell the court after talking with him, he became real clear to him that he needed to get booked in on these and was going to take action.
So, Mr. Patterson, as his character witness today, you are assuring the court that he just didn't understand, and that if I put him on probation now, he will understand?
That is what I got from him, and it seemed very sincere, Your Honor. Yes.
Do you think, is this a language barrier? Do we need to go back and get an interpreter?
No, Judge, there is absolutely no language barrier. I think he does understand English very well. Mr. Gonzalez.
Where is he, by the way?
I think his video, he was walking around. I think we lost his video.
Well, I can't have a sentencing if I don't have a defendant.
Judge, we will call him and make sure he gets back on there.
We have radio silence.
And my assistant's doing that right now, Judge, across the table from me.
Webster is not happy.
Well, if it's not a language barrier, what is it? What is it he doesn't understand? And don't answer that until we get him back here.
He's a jackass.
Your Honor, I believe he is supposed to be here and at the Sally Port today also.
Once the blue shirts from Sallyport get involved,
Judge, while we're waiting, can I inquire who Blade T2 Light is?
Oh, that's Ashley Lakin.
Okay, thank you.
Sorry, my phone died and everything, and I called the office and I was trying to get logged back in.
and you should see her. I have her too. She's a hot mess.
Well, he's doing it.
So he
Mr. Patterson,
doesn't
have
come
you heard from
back. All right, now 5 minutes later. No, it's about an hour or so later. Maybe even longer. Here's part 2.
Well, her track record is not good.
I gotta sound clip that.
And Judge,
Well, her track record is not good.
and Judge, did I hear Mr. Regier correct? The date on the bond was July 12th.
Your Honor, that's the date that I'm showing on this particular bond.
Well, my docket notes show that March 6, 2023, Savannah Medlin.
This was today, guys.
Oh, that was for setting her motion for judgment today. So the motion for judgment has been set aside again, and she is bonded out again. So who knows? Maybe this next time will be the charm. She'll show up.
Nobody was showing up today.
Do we have an address for her anymore? Did anybody ever get an address? See, that paperwork hasn't even caught up to the court files. It's happened so fast. All right. Well, I tried to help out there, but obviously other people have done things that I didn't know about. So we're on the record in 2023, CR 15, State of Kansas versus Raul Montez Gonzalez. Jared Regier for the state. Darren Patterson for Mr. Gonzalez. Now, what's the status of this one, gentlemen?
Judge, we were most of the way through a plea and sentencing. We got to the portion about him making sure that he gets fingerprinted and photographed, and then we lost his phone. He appears to be back.
Now, I think we were trying to figure out about sentencing, whether I should put him on probation or not, and that was an issue. Am I remembering correctly?
It was, Your Honor. You were considering that, and I was discussing my...
Good credit. Okay, that's right. I remember that. All right, Mr. Gonzalez, where do you live?
1165 Highway 196 here in El Dorado.
How long have you lived there?
Oh, about a year and a half.
Where'd you live before that?
707 West 13th in El Dorado.
How long did you live there?
Well, I built that house. It took me 20 some years.
And you know where the Butler County Jail is? The Butler County Detention Facility, as they call it these days, out on Stone Road?
Over there by the prison?
Yeah.
Yeah.
After your last hearing, did you go into a Sallyport breakout room and talk to an officer? And set up an appointment to go out there to get your picture and prints taken, to sign a bond?
Man, that's been about a year ago. I mean, I'm gonna say yes.
Well, one of those orders was just back in March. Do you remember that one?
I just remember the one that I had with you, and I was in Iola at a motel working, and that's the one that the only time I've been on Zoom on court.
Okay, now I have never been in a motel with you and Iola.
No. I was working over there, and then that's where I went to. That's where I had my meeting. That's the only time I remember, Judge.
Was that a Green
Webster said I was never with you in a motel.
Wood County case with me or a Butler County case with me?
No, that was a Butler. I was just working over there.
Okay.
She's the best.
That's the only hearing you remember?
Yeah, that's the only one that I remember, ma'am.
Your Honor, if I may.
Go ahead.
In both of these cases, I'm showing one hearing prior to this one. I was on both those hearings, and that was not before this court, but before Judge Satterfield on a summons. The notes that I have indicate that the defendant was ordered to be booked by today's date, May 1st. At that time, the defendant appeared pro se by Zoom and counseled, and the court did appoint Mr. Patterson to serve as the defendant's representation.
So your notes show that he was ordered to go out there and be booked.
Yes, Your Honor.
Do you have any notes to talk about him going to the Sally Port today?
Oh. Look at Sally Port, guys. Look at them.
Nothing to that specifically, Your Honor. However, it looks like in multiple cases, including 23 CR 15 and 23 CR 40, there is a jail affidavit that states, quote, that on March 10th of 2023, the defendant failed to report to the Butler County Detention Facility as directed by the court to be processed and released, which is somewhat different, but in any event, it would appear that this defendant was ordered to report for booking and processing.
Deputy Jared Dean.
Your Honor, if I remember correctly, he was, I think, on a job or something the last time and he couldn't make it. So on my notes, he was to show up. When he showed up today, he was supposed to either go out there today and get that done. And if basically that's what his order was, it was to get it done today. So he wasn't supposed to be booked by today. He was supposed to have appeared at the Sally Port and then gone out and got his pictures and prints.
Everybody's notes are different.
Judge, there's notes in case number 23 CR 164 when he was in front of Judge Satterfield saying pretty much that. It's set for 5/1/23 at 8 a.m. Defendant to be at the Sally Port for this hearing. Bond set at 2500 OR. Be processed the same day of hearing.
Okay, so that's for one of his 4 cases.
Correct. That was just on the CR 164.
Mr. Regier, thank you, Savannah. I'm sorry to cut you off. Then, Mr. Regier, you had some that said that he was supposed to what?
My notes from the previous hearing say that the defendant was to be booked May 1st of 2023.
All right. And somebody has jail sheets that say what? You had jail affidavits saying that he didn't go out there today or sometime?
Yes, Your Honor. It looks like that was at least in the 23 CR 15 case that was filed back on March 8th of this year.
All right. So after everybody contributes, it comes back to where we started. He didn't go out to the jail and get his picture and prints taken when he was supposed to, because he's not out there now, are you, sir?
No, ma'am.
And he didn't go to the Sally Port as he was supposed to today, because you're not there at the Sally Port, are you?
What is the Sally Port?
It's the jail there. It's the detention portion of the courthouse where Deputy Caulfield is.
Okay, sorry.
All right, so we come back to what I said initially. If I can't trust you to do what you're told to do, how do I succeed with you on probation? But in any event, what the heck? We're going to try it. We're going to just see. Can you get out there and get your picture and prints taken today?
Yes, ma'am, right now.
Where are you right now?
At my house. I just hop in my truck and go.
Finally.
Make sure your license is valid, which that's not your issue. Your issue is violation of protection orders. Now, when those orders were issued to you in the protection case, whether it was protection from stalking or protection from abuse, you were told not to have any contact with this lady who's now been determined to be a victim, right?
Correct.
Did you have any misunderstandings about that?
No. I'm one of those cases, I was just trying to be a nice guy about giving her a washing machine and dryer because I knew that she didn't have one. So I went through her father to ask her if she wanted it, and if she did want it, for her to make arrangements to come and get it. And
we already have established that this guy is the biggest liar, not at the Sally Port, and anything that comes out of his mouth, especially over his PPO, is garbage.
And that's the only one that I remember. I don't remember the other ones.
Well, 2 of the 4 cases were dismissed for your plea agreement.
Right.
But between those 4 cases, you had a string of violations of protection order violations from September through,
betray.
I don't know, May of some point, May of 22, maybe I've, You've had so many violations, I can't even keep track of without having them right in front of me on the screen. But I don't want you to ever come back here again and say, I didn't understand what was ordered. So
That's what Mr. Patterson said. That's what Mr. Patterson said. He said, if you see her, just run the other way. Run like the Dickens. So I'm taking that to heart.
Well, it's a shame you didn't take the judge and the protection from abuse order at heart when they said that. All right. So I'm going to go with this plea agreement, and I'm going to give you a chance on it. But I'm skeptical because you haven't been able to understand or follow anything you've been told yet. In the civil protection order, in the 4 criminal cases, even when you were told to go to be at court in the courthouse today.
Oh, he was supposed to be
in
at
the
courthouse.
CR40 case. Count 1, 12 months probation. Count 2, 12 months probation concurrent.
Hey, ma'am. Just one question, because I don't want to get in trouble getting in contact with her. And sometimes I have trouble my little girl answering the phone, because my little girl tells me that she takes the phone away from her to go look through the emails or to messages. Am I allowed, can I buy her a phone, my little girl?
That's not in my jurisdiction in this case.
And Judge, that was one of the things I said earlier. Ms. Norris and I had discussed requesting the court to allow him to have contact through a third party only, and only for purposes of their child they have in common.
That I would agree with, and I would order that. And Mr. Gordier, if you could put that language in the journal entry. But whether you get her a cell phone, no, I'm not going to get into that and grant that. All right, so 12 months, no fines, 250 of your attorney fees you will pay, $158 of your court costs, $60 of your probation fees. You will see your probation office as directed, and you will call that office as soon as this hearing is over at 316-322-4153. All standard conditions will apply. You will not have contact in any way, shape, or form with this victim. Don't text her, don't email her, don't call her dad and see if she can have a refrigerator.
Okay.
This was gold.
In the CR15 case, again, 12 months, concurrent with each other, but consecutive to the other case. So that if you get revoked, you're going to serve 12 months on one, and then you're going to start another 12 months on the other.
It's malfunctioning.
You are going to pay at least 1/12 of the total due each month. And that's 250 plus 158 plus 60. So at least 468 divided by 12, with the first payment due on May 30, well, the last business day of May. Maintain a full-time job, that's a standard condition, and I intend for you to comply. But you're going to go out there today as a condition of your probation and get your fingers and prints taken in all 4 cases, including the 2 dismissed.
Okay.
And if they're not done, that's a violation of your probation. If you don't show up when you're supposed to, that's a violation of your probation. And if they tell you where to show up and it's not convenient with your work, you better be there anyway.
Okay.
You don't strike me as a dumb person. You don't strike me as someone who is language impaired. You strike me as somebody that does understand what's going on around you. And I expect you to start complying. Anything else, Mr. Regier, we need to address?
Your Honor, so the underlying sentences are to run concurrent to each other in the individual cases, but consecutive to the other case?
Yes, exactly.
Thank you, Your Honor.
You're welcome.
And I'm assuming the probation officer has discretion as far as payment is concerned.
No, I want him to pay at least the 12th in each case, starting with May, the end of May. And a probation fee in each case, $250 for a Attorney fees in each case, $158 for court costs in each case, $60 supervision in each case, for a total of $468 in each.
Thank you, Your Honor. Your
Mr.
Honor, I'm sorry, if I may.
I was gonna say, Mr. Smith, you're here. I don't know if it's for this case, but what would you suggest at this point?
Yes, Your Honor. On this case, I would just ask the defendant, since he's going to be out and about, that he just report here in person today to get the paperwork filled out and started.
He won't.
Okay, so do you understand that, sir?
Yeah, what's the address?
You're going to go to the courthouse. It's the newer of the three courthouses. They're together.
Okay.
201 West
I don't know
Pine.
daylight.
Go in there and check in. What's the latest you want him to check in? It's like 12:25 now.
I would just say as soon as he's done with the jail, he can report, but no later than 3.
All right. And Deputy Caulfield, can you get the jail to get him in there this morning? This afternoon, I guess it is now.
We're telling the jail that he needs to be done. We're on the phone with him, talking to bosses to see if it could get done, because the gal that's normally does it isn't there today. So
Okay.
we're going to see what we could do.
All right. I'm going to put
All
you in
hands
contempt
on
in jail,
deck.
Mr. Deputy Caulfield, if that's not done.
This is a Butler County
You
emergency.
know better than that, don't you?
I
'Cause I know you do what you can. I know you
I
do.
could use a couple of days rest probably.
All right. Anything further, Mr. Patterson?
Oh,
No, Your Honor, thank you.
You guys are the
Okay.
best.
Mr. Gonzalez, you're somewhat free to go. Not really, because you still have several things you have to do, right?
Right.
Okay. Do
Well-
not forget. Okay, head out to the jail.
All right. Thank you.
All right. Thank you, sir. You may go.
Why do we have a feeling we're going to see him in about 2 weeks on a probation violation? He's not going to come up dirty for urine or anything like that. He's just not going to show up, or just a no-show, or offer to buy his little girl snacks or something. Like, it's going to be something so stupid. Webster's going to lock his ass up. All right. Let's go to my girlfriend, Judge DeSanto. Not the one everybody thinks I'm gonna play. That one's gross. I'll go to another one. There was another one that was not as good, but it was up there. Here we go.
March 31st of this year, failed to appear for drug testing April 11th of this year, and failed to pay. And counsel?
Yes.
That's correct, Judge. And at this time, after speaking with Ms. Barbaro regarding the allegations, we are prepared to enter a guilty plea. I did explain to her her right to have a contested hearing, and we are prepared to waive that right.
All right, ma'am, please raise your right hand. You solemnly swear affirm the testimony your testimony here today will be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Okay, the court will also note that your client is currently on probation for failure to report an accident as well. And so, ma'am, you heard the plea that your attorney indicated on the record, correct?
Yes.
As to the allegation that you failed to appear for drug testing on April 11th, failed to pay and tested positive for marijuana on March 31st, how do you plead?
Guilty.
And you understand that you have the right to have a contested hearing in these matters. By entering into a plea, you will not have that contested hearing.
Yes, ma'am.
And you signed your advice of rights for probation violation purposes, correct?
Yes.
And you read and understood all of those rights prior to signing it.
Yes, ma'am.
And you also understand that you'll be waiving some of those rights by entering into a plea.
Yes, ma'am.
And you understand the possible penalty as a result of your plea today, specifically the recommendation that this court could deviate from, adopt in part or not. And the recommendation is for you to continue to complete all terms of probation, pay a $50 probation violation fee, 5 days jail, mandatory additional jail, and revocation of probation for any future violation. You understand that that's the recommendation?
Yes.
And knowing all that, you still want to continue with the plea?
Yes, ma'am.
And has anybody promised anything, threatened you, or coerced you in any way for you to enter into a plea?
I'm sorry, can you say that one more time?
Has anybody promised anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
All right, and counsel, if you can please budget your client.
Sure. Ms. Barbaro, is it true that you're currently on probation on the Wyandotte District Court?
Yes.
As a term and condition of probation, are you to not test positive for any drugs or alcohol?
Yes, sir.
Did you test positive for marijuana on March 31st of this year?
Yes, sir.
Another term and condition of your probation, are you to submit to drug tests as ordered by probation?
Yes.
Did you
Yes.
fail to submit to a drug test as ordered on April 11th of this year?
Yes.
And finally, are you to pay all costs and fines to this honorable court or adhere to payment plans that you've set up with the court? Did you fail to make any payments as required by the court? Okay.
Yeah,
And you understand that all?
Ma'am, you need to let Mr. Westmoreland complete the question before you interrupt him, because my recording is not able to pick up both of you. So please let
I'm
him
sorry.
finish the question first. And myself too, please. Thank you. You may continue, counsel.
And you understand that all those three violations are direct violations of your probation through Wyandotte District Court?
Yes.
Okay. Satisfied, Your Honor.
All right, the court is satisfied that the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation. Indicate that technical violations number 4, 5, and 6 will enter. And counsel, as to the recommendation.
As to the recommendation, Your Honor, I would ask for a deviation from it and suspend any sort of jail time. I would like you to know that Ms. Barbaro, she's currently not working, which is rendering her unable to pay her costs and fines. She knows that she does owe them to this honorable court. She has been in and out of the hospital due to health reasons. I didn't want to dive into that and ask her what sort of reasons. I didn't want to violate HIPAA or embarrass her in any way. But she is extremely apologetic. She's trying to get her life back on track at this time. So at this time, I'd be asking to suspend any sort of jail time on her back. She's taking responsibility for her actions. She hasn't tried to deceive this court in any way.
Okay. Ma'am, are you driving right now? Because it looks as though your vehicle is moving.
I'm in the back seat of a car. I'm on my way to work. This is my first time I've been able to work in the past 3 months.
He started a new job today.
Where are you working?
In the city, Detroit.
Okay, well, that's a large city and with lots of employers. Where exactly do you work?
I do the modeling.
Okay. And you were placed on probation November 30th.
DeSanto gets catty here.
Have you worked since November 30th?
Yeah.
A model, huh?
And so please explain to me how it is you you work. Is it on an on-call basis, or do you have to be selected for a job?
It's
How does that
kind
work?
of just whenever I can find a job. It's a self-employment job. But I recently, I've been out of work for 3 months because I have been in and out of the hospital. I sent over my paperwork to Natalie for probation so that she knew exactly what was going on. And that was the reason that I missed.
This is the wrong chat room to have her say she's a model.
My color that day.
What was the reason why you missed your call that day?
I've been in and out of the hospital with major health problems. I sent over all my paperwork to Natalie so she
I
knows
understand that.
exactly what's going on.
Okay, my question is, ma'am, on April 11th, were you in the hospital?
I'm not, probably not, but it must have slipped my mind just because I've been so sick.
I just had a procedure done on last week, so I've been, you know, recovering from that, and I'm feeling a lot better now.
Okay, and so were you in the hospital on March 31st? Or March 30th?
I don't think so, on those days. I wasn't aware that I missed something on that day.
Well, you missed not using marijuana. That's when you tested positive for marijuana, man. And I'm presuming the hospital didn't prescribe marijuana to you, did they?
I have it approved by my doctor. I just haven't been able to get in any of the paper, like I've been so broke that I wasn't able to get the physical card in time, but I can send that over to the.
Dan, that's not how it works. You're on probation. This court indicated that you cannot use any alcohol or drugs that are not prescribed. This court also, and probation also made it clear to you how to go about being able to use marijuana while you're on probation. So did your treating physician that you've had these major health issues with prescribe you your marijuana?
No, I had to get that through, like because it had to be approved by a primary care doctor, but you can't get the physical card through the primary care doctor.
Okay, or the primary care doctor would be the one to refer you for your marijuana. And you don't have any of that, do you?
Not at this time, no.
So you're not allowed to use marijuana, ma'am. And there's a victim in this matter that you were ordered to pay restitution to. Have you made any payments, ma'am?
No, I haven't made any payments. I haven't been able to make any payments.
Ma'am, you were sentenced in November. We're going on 5.
I know, I understand.
Please don't interrupt me. And you haven't made one payment. You haven't made one payment. How do you support yourself? If you're not working, how do you support yourself?
I've been struggling at home to pay my own rent and everything and keep groceries on the table for my kids. I've been financially really unstable lately.
So ma'am, instead of relying on your self-employment modeling, perhaps you should get a more stable and secure form of employment.
You're right.
And you may be struggling to pay your rent and feed your children, but how do you know the victim in this matter isn't doing the same, that they were out of pocket based upon your actions?
I understand that.
It's not just about you.
I know. No, I know that. And I apologize for everything. I don't mean to be slacking. The last thing I want to do, I just want to get this done. I wanted to get it done the right way. I've had a couple slip-ups, and I'm extremely apologetic for it. I had a miscarriage, and I had to get a DNC done, and I was in and out of the hospital very sick because of it. And it's just been a really rough 2 months for me.
Well, I can understand that, ma'am. I'm sorry to hear about your loss. However, you made it appear as though you sent in the paperwork to Ms. Shaw that you've been in and out of the hospital, and you sent that documentation, and you made it sound as though you've been doing that, keeping her apprised along the way. But that's not actually the case, is it?
Oh, I've been trying to keep in contact with her as best as I can. But I'm usually really good about calling my caller every day for the drug testing, and I don't know. I had severe nausea also, so it was just.
Well, ma'am, you made it sound as though when you were in and out of the hospital, that you were staying in communication with Ms. Shaw, but you weren't. The only reason you contacted Ms. Shaw regarding your, medical issues is because you received your probation violation information in the mail. That's why. Okay, I need you to stop walking, please, to stay in one spot.
I am. I was just walking over here.
She's never going to make good money working the day strip at the day the day shift at the strip club.
And so,
Legs and eggs.
so that you were seen and apparently discharged the same day, April 13th. Which was not a day you didn't appear for your drug testing. And so you were 2 months pregnant and you were using marijuana?
No, I didn't. I was only 6 weeks pregnant. But so when I got back from my last job, I usually only go once a month, so that set me back an extra month. And then I was only 6 weeks pregnant when I found out I was pregnant.
Wait, I'm sorry, what?
I usually go at the end of the month of every month when I work, and I let Natalie know so I can get my breathalyzer. And then, but I didn't have work that month, and I was relying on my taxes to pay you guys, but I ended up having to pay my rent and everything, and it just set me back so far. And then all this happened, and it set me back even worse.
Okay, ma'am.
And I understand that $50. I'm sorry.
I think that you're not understanding my question. You testified in this court that you were 2 months pregnant. You had a miscarriage.
I was,
And
yeah.
so-
Yeah.
Okay. You're 6 weeks pregnant, but yet you tested positive for marijuana while you were pregnant.
That was before I found out.
Okay, but you're not allowed to use marijuana at all anyway.
I know.
Okay, well, the court's going to adopt the recommendation. Ma'am, you have excuse after excuse as to why you're continuing to violate. There are technical violations 4, 5, and 6. And the court's going to indicate your continued complete.
There's her house mother.
$50 probation violation fee, 5 days jail. As based upon the last violation, this court indicated mandatory jail for any future violations. Well, you've had 3 of them now. 5 days jail, mandatory jail, additional jail, and revocation of probation for any future violation. And so you are to report today, ma'am, by 6 o'clock. You have to report. You need to email into Ms. Shaw as to what you need to do to report.
Okay.
Okay. And I suggest you start making some payments, at least on the restitution for the poor individual that whose vehicle was damaged.
Yes, that was my main
concern. As a result.
She's probably got a DUI.
As a result of your actions.
Craig, she's working
Yes,
the day
ma'am.
shift. Told you.
All right, the court will indicate that's concurrent, 5 days on each case. It's concurrent.
So is that 10 days?
No, concurrent, consecutive would be 10 days, concurrent.
Dumbass.
is 5 total, because these are running concurrent and they're running together.
What a dumbass. At that time, at least I'll work on my figure. Kind of have baloney.
And are you now inside of the location or are you still outside?
She's still busting
I'm
the
inside.
chops.
And then I asked you to stop walking around. That's what I
Yeah.
asked you to do. Stay put in one spot, but you're not doing that. You're having a hard time following instructions of any regard.
I'm sorry. This was the first time I got a little bit of work.
Ma'am, get a job that's more stable, that you can provide for your family. So you're reporting tonight by 6 p.m., so hopefully you're done working, you've made arrangements with everything.
Oh, she's locked up right now.
Yes, ma'am.
She's in the clink as we speak. Working on the chain. Gang. DeSanto strikes again. The Viper.
Okay, anything else, Council?
Not this time, Judge.
All right, thank you.
See ya! Guys, it's been awesome. Hope you enjoyed the clips tonight. Just say a prayer. I had a loss. One of my students passed away in a tragic car accident over the weekend with this horrible weather. Half of his family. I don't like dropping bad news, but you guys cheered me up. I had to go live tonight because I was going through it. So I really appreciate you guys hanging out more than you guys should know. I'll see you guys tomorrow. See you guys in the chat tomorrow. Make sure you kiss your loved ones. God bless. You've been served.